Very good. Good evening, everyone. I'm calling to order a code enforcement hearing of the City of Cape Canaveral. Today's date is April 25th, 2023. My name is Richard Geller. I'm a special magistrate appointed by the City Council to hear code enforcement cases pursuant to Article 6 of the City Code and Florida Statutes Chapter 162. We'll be holding two quasi-judicial evidentiary hearings tonight, one of which is known as a Massey hearing. In both instances, the burden of proof is upon the city to show by a preponderance of the evidence that a code violation exists, or in the case of the Massey hearing, continues to exist past the date established for compliance in a prior order. In other words, I will determine based on the evidence presented to me this evening whether it is more likely than not that a violation has occurred or continues to occur. The alleged violator will have an opportunity to submit any rebuttal or exculpatory evidence, including testimony. At my discretion, I may allow a member of the public with relevant personal knowledge to testify, even if not called by either the city or the responding party, and anyone who would like to testify should so indicate. Upon request, an alleged violator may ask relevant and material questions of any city witness, and the city may ask relevant and material questions of any witnesses for the responding party. I may exclude evidence that I deem irrelevant, immaterial, or unduly repetitious. In the case of the Massey hearing, that is a hearing to determine whether a violation continues to exist in violation of a prior order that I have submitted. I will be determining fines. In determining the amount of any fine, I will consider the gravity of the violation, any actions taken by the violator to correct the violation, as well as any previous violations committed by the violator. Under the City Code and the Florida statutes, I may assess and order the payment of fines of up to $250 per day per violation for a first violation, and up to $500 per day per violation for repeat violations. Or, and this is very rare in the case of a violation that is irreparable or irreversible, a fine of up to $5,000, as well as the cost of any repairs made by the city. At the conclusion of each hearing, I will issue findings of fact and conclusions of law based on the evidence of record presented to me, as well as an order, both here on the bench and in writing, and I always endeavor to do it within the next day or two to get the written order submitted to the city. The city will record a certified copy of any order imposing a fine, which will become a lien against the land where the violation occurs, as well as upon any other real or personal property owned by the violator. Any order I issue may be appealed by any party to the Circuit Court for Brevard County within 30 days. It is the responsibility of the appealing party to obtain a record of these proceedings, and appeal is limited to the record that is presented to me. I have signed and approved the minutes from the last hearing, which was all the way back on February 28th, 2023, and I'll give these to Ms. Roth at the conclusion of the hearings. The next meeting date will be held on May 23rd, 2023, same place.
Sir,
Yes.
can I tentatively, or the city tentatively change that to May 30th? That would just be the next Tuesday. It would be the last Tuesday of the month instead of the fourth Tuesday.
I'm not sure I'm in town on May the 30th.
Tentatively, if you could look at your schedule when you get back and get back with me, then we can adjust from there if you want to.
I can tell you right now that on May 30th, let me see. Oh, well, no, I should be here. It looks like I'm probably leaving town. I think the 30th will work fine.
Okay.
That should work fine. Okay, we'll talk further. So let's tentatively say May 30th, 2023 for the next meeting. If it does not take place on May whatever the date is, the city will duly notice it.
Thank you.
And then at this point, I would like to swear in any witnesses. So anyone who believes that they will offer testimony for either of the matters that will appear before me, if you could please stand and raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you very much. All right, well, the first case on the agenda, case number 2022-13, alleged violations of section 110-486 vacation rentals, and then 110-487 rental restrictions on dwelling units. The property owners are indicated as David Jones and Heather Parker Jones. And is the city ready to proceed?
Yes, sir.
You may. Go ahead.
Okay, this is case number, I'm Officer Chris Robinson.
Thank you.
This is case number 23013. Before we get started, there was a error in the description of the violation on the original notice of violation that was sent out that we didn't catch until recently. I've notified the Joneses of that error. If you look at the original notice of violation, the description says 290 Canaveral Beach Boulevard instead of the 200 Madison Avenue.
Okay.
I don't know, what you want to, if you want to proceed with this, or if you think that we should properly notify them and have another hearing. I just want to make sure they have their due process and everything is done right.
I agree. Are the Jones here?
Yes, sir.
Okay. So the question is, and so let me turn this over to Mr. and Mrs. Jones. If you could come to the podium, and I want to ask you about the city's error. So the city acknowledges that the notice of violation contained an error as far as the address was concerned. You have the right to insist upon proper notice. So either we can hear this matter tonight, if you feel prepared to do so, if you were not confused by the notice, or we can reschedule this for the May 30th hearing. So I'll go by whatever your preference is, and do you have a preference?
We're here, so we'll go ahead.
You like to? Okay, so may the record reflect then that you are waiving any inaccuracy in the notice of violation. Yes. Okay. You agree with that, Mr. Jones?
Yes, she speaks for both of us.
Okay, very good. Then we'll go ahead and proceed tonight. Thank you very much.
Thank you, Your Honor. Okay, this is for violation of the vacation rentals and registering. Notice of violation was sent out on January 24th, 2023. It was returned to the city. The property was posted on 3/2/2023 in accordance with Florida statute. Notice of hearing was sent out April 4th, 2023. It was also returned to the city. Property was posted on the same day in accordance with Florida statute.
I got it. Thank you.
This is the property in question. It's at the intersection of Madison and Poinsettia Avenue. On January 9th, 2023, staff received a complaint from a Dana at 202 Madison Avenue stating the property is being rented for less than 7 days and the renters are loud. Further investigation found the property on Airbnb, which is being advertised and allowed to rent for less than 7 days. The property is also not registered with ProChamps, and the property owner has not obtained a business tax receipt. January 23rd, 23, staff was unable to make contact with the property owner. A notice of violation was issued. March 2nd, 23, staff checked the USPS tracking system and found the certified letter has been returned to the sender. Notice of violation was posted on the front door in accordance with Florida Statute 162.12. 4/4/23, staff has had no contact with the property owners, and a follow-up revealed the violations remain. Notice of hearing was sent to the property owners, and the property was posted in accordance with Florida statute. 4/5/23, staff received a phone call on or around this date from Heather Parker Jones in response to the notice of hearing posted on the door. Staff explained the violations of what needs to be done to come into compliance. Ms. Parker Jones said she would take care of it. 4/13/23, staff spoke again with Ms. Parker Jones. She said she's still working on the issues but is having difficulty getting with ProChamps. Staff advised to do what she can to control prior to the hearing. Today, follow-up inspection found the property owners have not registered with ProChamps and have not obtained a business tax receipt. A visit on Airbnb revealed there has been a change showing a 7-day minimum.
So, 1 second, so it was on 4/25, which is today's date. So business taxes have not been paid,
That's correct.
and then we still don't have no registration with Pro Champs.
That is correct.
And, but they have corrected the 7-day minimum issue as far as we know. Okay. And was the city informed what the nature of the difficulty in getting the registration with Pro Champs?
They were just playing phone tag, she said. She may have more information tonight, but she was just having difficulty speaking with them.
Is this something you can do online? You go to their website and you register?
I'm not sure how it's done. You can call them, you can do it online. I'm not 100% certain how it's done. But she was having difficulty getting with them.
It would just seem in this day and age that this is something that shouldn't be so difficult. Okay. Anything further?
No.
All right. Well, Mr. and Mrs. Jones, if you'd like to come back to the podium. Sure, may the record reflect that I've been given some written materials. We will, I'm going to mark this collectively as Respondents Exhibit 1. And could you please state your name and address for the record, please?
Heather Parker Jones, 7228 Winding Lake Circle, Oviedo, Florida.
Okay. And
Dwayne Jones, 7228 Winding Lake Circle, Oviedo, Florida, 32765.
all right. And just for the simplicity of the proceedings, well, Mr. Jones, I think you said that Mrs. Jones is going to speak for you, but if we just let her start, and then we'll give you an opportunity to add anything that you would like. You may proceed, Ms. Parker Jones.
Okay, so this is all procedural. So the issue is just getting in touch first with Pro Champs. I had questions.
Yes.
So we weren't familiar with the process. So I just needed to talk to them about the process and find out what I needed to click on the website to make sure I was complying with what I needed to do. Okay. So I called them on April 10th, left a message. I left a message on April 13th, left a message. Somebody called me on April 14th, and they called, her name was Alicia. She left a message with me. When I tried to call her back, there was no response, couldn't get through. So finally, I was able to get through with them, and they told me that I needed to go online to start the process, and they gave me the information, answer the questions I needed to know. So the first thing was that I needed to have a business tax receipt. So when I got in contact with the city of Cape Canaveral and asked about that process, someone on the phone walked me through that process. I went online and I did the business tax receipt form. I sent it in via email to the website that they told me, AFS, to the email. I never got a response. I said, how do I pay? I'm going to send you this through email, but where do I pay the fee? She said, you don't pay until we get back in touch with you. And they never got back in touch with me. This was on April 20th. Okay. And so I called again this morning because I looked through my email, thought I missed it, looked in my junk mail. She said, oh, we never received it. Where did you send it? I said, AFS. She said, well, our supervisor has been on vacation.
Okay. Just slow down 1 second, because I want to make sure I'm understanding the sequence of events. So, Alicia leaves you a message on the 14th. You're finally able to speak to Alicia or someone in customer service with Pro Champs. Somewhere, was that around the 14th?
It wasn't on the 14th, but I kept calling back, and we finally made contact with each other.
Okay, so at some time after the 14th, and you spoke with Alicia or someone else, do you know?
I spoke with about 3 different people at Pro Champs.
Okay.
Alicia was just the first one.
Fair enough.
Yeah.
And then, so she then explained that you need the business tax receipt.
Before I could register with Pro Champs.
Okay, that makes sense. And so and so do you know the approximate date when you're given that information?
It looks like, so the 14th was when I left another message. So it was between the 14th and the 20th.
Okay.
Because on the 20th is when I sent the business tax. So it was the 20th is when I actually spoke with her. So then I started the process of doing the business tax tax receipt.
Okay, so on the 20th is when you contacted the city of Cape Canaveral to pay the business tax?
Yes.
Okay,
So, on the 20th, I went online and I submitted the paperwork
okay,
via email. The forms are available on the City of Cape Canaveral website, so I
Right.
downloaded them, sent the forms in, and I never heard back so that I could then pay.
okay. When you say you sent them in, was this sent in through
Email.
US mail, through email?
Yeah.
Okay. Via email, that would have been on 4/20?
Yes.
Okay, all right. And you haven't heard back?
Haven't heard
And you
back.
followed up today, and that's when they said they had not received it.
Right.
And someone was out of town who would have received it?
Yeah, I spoke with Kelly Bowen today, and she said that she didn't have access to the AFS mailbox in order
Okay.
to retrieve those emails.
I see.
So I told her, okay, so she said I could send them to her directly, which I did. But she also said that she would find someone to get into the email box so that they could find the original ones.
And what was Kelly's last name?
Bowen.
Bowen?
Yes.
All right. And so she did not have access to the mailbox where you had originally sent the forms. However, you resent them to her?
Yes.
And that would have been today?
Yes.
Okay. All right. And by any chance, is that in here, in these materials? Okay. All right. And anything else you'd like to share with me?
No, just want to, once I hear back from them, I just want to get the business tax receipts paid so that I can then register with ProChamps.
Okay.
And then those three stipulations will be adhered to at that point.
Okay. All right.
Okay?
Anything else? Mr. Jones?
Yeah, you can switch places.
Yeah, got it. So I don't know if you're able to do this, but we're asking for some considerations. So some background. We've been here since 2007. We've owned our property, a different property here since then. It was our vacation property, property for our parents, property for our kids. During COVID, like many other people, we had a lot of financial, personal hardships. Her job was downsized. We didn't have income. So we made a conscious choice to take our life savings, plus we invested some other money out of our insurance policies to purchase the 2 rental properties that we purchased and to spend about $300,000 fixing them up. In addition, we've complied with Cape Canaveral's solar initiative, and this is inside of the handout, where we put solar panels on all 3 of the properties. We generate local income through the groceries, restaurants, rental cars, beach rentals. We hire local landscapers, handyman, plumbers, electricians, pool service cleaners. We're rated on Airbnb as the highest rating that you can get as a superhost status.
I'm sorry, super what status?
Superhost.
Superhost. Okay.
We have a 5 out of 5 rating for quality from our rental customers. And none of our bookings have we ever rented for less than 3 days. As soon as we found out that there was a restriction for 7 days, we immediately complied, changed the website to 7 days. Unfortunately, since that time, we've gone from being a superhost where we've had all of our rentals booked up, we've had not one rental since we've switching to 7 days. So we are now in financial dire straits that without any concessions, we're looking at an imminent amount of time before we have to file for foreclosure on our properties. What we're requesting is a moratorium for 3 years to be allowed to continue to rent for 4 days minimal, so that we can recover the huge investment that we put in. At the end of that time, we will gladly comply with the 7 days or longer rental. Short of having any concession, it'll be a matter of 2 months and we'll end up being foreclosed. And that's inside of here what we're requesting.
So so when we say 4 days, we're not saying that we would have more than one family in that 7 days. We're saying we want to comply so that not any more than one rental takes place within the 7-day period. So we would block off the rest of the week. So if we have someone coming in for 4 days, as shown on that schematic there, then we would block off the rest of the time so that the 7 days we be in compliance. One family, one rental group only for 7 days. So we would just take whatever we're getting for the 4-day rental, and then the rest of that time, that would equal 7 days, would be
Well,
blocked off.
actually, that's the second option we're asking if we can't get the first option. The first option is if we would be allowed to continue to renting with the minimum of the 3 to 4 days, how we have been renting for the 3 years to try to recover this $300,000 that we've put into the investment. If that concession isn't allowed, then we're asking for the concession that my wife asked. And then I'll clarify this. And then third, if these concessions are allowed, the way that Pro Champs is set up now, they can't do any concessions without the city of Cape Canaveral approving it. So we can only list rentals for 7 days. With the concession, if we had a family that wanted to rent for 4 days, but then we were able to block the other 3 days off, we can't do that the way that it's listed now. So we would have to be able to list without it being listed on the website saying 7 days, but being compliant with the 7-day rental by blocking the other time off.
And that's what the Pro Champs people said. They said that they can help us do that if the city, they can help us, monitor that that's blocked off for that period of time if the city of Cape Canaveral approves that we can monitor the blocking off ourselves. And Pro Champs would help monitor that.
And then just to add, this is in this packet also, I am a veteran. I am a disabled veteran. I've provided the paperwork in there. All of our properties are registered through the state of Florida. The certificates are there. The tax ID numbers are in the packet that we provided. We are a minority company. We're African American, female, and disabled veteran. We just don't want to go under right now. We've put our life savings. COVID devastated us. We decided we would never be in a position again where income from jobs would determine whether our house was financially stable or not. This was a purposeful plan that we did. We just unfortunately did not know of the 7-day rental restriction.
Okay. Anything else? Anything you want to explain that's in
It's all
this
in
paper?
there, yeah.
Right. Is there, all right. So if you'll give me one moment, I'm gonna look at what you've given me in writing and see if I have any questions. When did when did you start the 7-day minimum bookings?
When I spoke with Chris, when he told us about, when I called him to find out what the violation was about, so that's when I started the 7 days.
Can you give me an approximate?
April, when did we speak? Oh, spoke with Chris on, let me see a date on here.
So it was around April the 10th or so, because you already spoke to Pro Champ, so you already did it. So it's probably between the 6th and the 10th, don't recall exactly the date.
Okay.
And since that time, not one booking have we had, and we're a super host with a 5 out of 5 rating, and we haven't had one booking.
So basically, we're talking 2 weeks, more or less, that you've not had any bookings.
Correct.
Okay,
And
all right, all right. I'm just reading your letter, Mr. Jones. It says, "Dear council members," I'm not a council, I'm just the special magistrate.
We had to come before to get an approval for a pool. We had a full council, so we just thought it was
Okay.
going to be multiple.
That's fine, that's fine. So it's actually Dr. Jones and Dr. Parker Jones then? So, okay,
We're Mr. and Mrs. before doctor. We go by both.
that's fine, thank you. How many properties do you own in the city altogether?
3.
Okay. So when you say you've not received any bookings since in the last couple weeks, that's referring to all 3 properties?
All 3 properties.
Okay. All right. Very good. If there's nothing else, I'll let the city step back to the podium. I guess my first question to you is and I don't have the language in front of me, but when they say, can we allow someone to stay in the rental property for, say 3 or 4 days, but we're not going to book it, for the rest of that 7-day period, is that something that the code allows?
No. And the city manager's been very specific about that it's 7 days, period.
Okay.
So the only thing that we can do here is we have to enforce the code. I don't have the authority to go outside of that.
Nor do I.
Right. So what we're recommending is that we find them in violation. They need to come into compliance. However, there's a different path that they could take with the city and possibly get a special exception and claim a hardship that way. But for the time being, we're asking that they come into compliance with this, and then that's something that I can discuss with them on. Maybe something can be done for them on that.
All right. And then for special exception, what board does that go before?
Well, the first thing you do is I have to speak with that director, that individual. I have to speak with them and submit everything, have those discussions to see if it can even go forward. That's beyond my scope. That's something they'll have to have a discussion with somebody else on.
Okay. And then as far as the registration with the city for the taxes, there seems to have been a little bit of the delays caused by someone being on vacation or sick or whatever.
Yes.
What's a reasonable amount of time to give the Jones to get that all sorted out?
I was going to give them until May 23rd, which was going to be the next hearing, but we've changed it to the 30th. But May 23rd is still ample time to get all this taken care of.
All right. I'm going to say right. Well, even if it's not, even if there was not compliance by the 23rd, that wouldn't be enough time to get it before me on the 30th for any kind of follow-up. So it would.
I would bring it back in June.
It would be in
If there
June,
was still
right.
a violation, I would
Okay.
have a massey hearing in June.
All right. Well, let's go ahead and say till May 30th, 2023 as a compliance date would be. I think that would seem reasonable to me. So, anything further?
No, sir.
All right. Right. Well, I think if there's nothing further by anyone, I'm ready to issue an order here. And let me preface this by saying that I'm sympathetic, and I wish that you have great economic success with all three of your properties. And I don't know that 2 weeks is enough of a time period to judge that this is going to be going down financially and in flames necessarily. But I hope that there's a turnaround. And but unfortunately, I'm not the person who can do that. I have very limited jurisdiction to determine whether a violation of the code has occurred. I am not empowered under either the city code or the Florida statutes to issue moratoriums on the enforcement of the code, or to allow variances from the code. I just have a very limited power. Is there strict compliance with the code or not? And that's the limitation that I'm faced with tonight, as sympathetic as I am to what's happened. And also, I believe that getting the business taxes taken care of by the end of May, I think that's ample time to do that, and to get the pro-tramps registration done. So that I think that's eminently doable. So my findings of fact are that Dr. and Dr. Jones owned the subject property. I would say that that as of today's date, the Jones have not registered the vacation rental property at 200 Madison Avenue, Cape Canaveral, with pro-champs. I find that the Jones are now in compliance with the requirement to not rent the property for less than the 7-day minimum by the change in the advertising that they have made. I find that all the notices, the notice of violation, the notice of hearing, either complied with Section 2-253 of the City Code and Florida Statutes, Section 162.06 and 162.12, or the defect as to the address was waived. And so I'm finding that there's a violation of Section 110-486, which governs vacation rentals in the city. And then just for the record, it says that prior to initiating the operation of a property as a vacation rental owner, either personally or through an agent, shall register with the City of Cape Canaveral utilizing forms promulgated by the city. Registration may be conducted by electronic means through a third-party contractor retained by the city for that purposes. That would be pro-champs. Separate registration is required for each vacation rental. I'm also finding that there was a previous violation of Section 110-486 for rentals of the property for less than 7 consecutive days, but that this violation has now been corrected. And so the difficulty here, and I'm going to read this from the statute for you. It shall be unlawful for any person to rent a dwelling for less than 7 consecutive days in any zoning district. There's an exclusion for hotels and motels. and vacation rentals in the C1 zoning district. And just for the record, do you know the zoning for this property?
It's R2.
R2, okay. So that exception does not apply. All right. And so the idea that you had of, let us rent it for 3 or 4 days, but we won't rent out the property for 7, the difficulty there is this code says that it cannot be rented out for less than 7 consecutive days. And so that precludes the type of alternative relief that you were suggesting. And so again, we're going to give the respondents until May the 30th to bring the property into full compliance by taking care of the business tax and taking care of the per-champs registration. And then my order is going to prohibit any rentals for less than 7 consecutive days, pending any relief from an appropriate board of the city. Is that how I should say?
Yeah, whoever, I don't know what the process is, to be honest with you. They'll speak to an individual, and then it'll go from there.
All right. If there is not compliance by May 30th, then Officer Robinson will schedule a compliance hearing before me, and only at that time would fines issue. So there's no issuance of any fines this evening, and you would have an opportunity to appear at any further hearing to present testimony and evidence as to whether a violation is continuing on the property. I would, and I've earlier in the hearing, I did say that fines can be granted, or fines can be assessed up to $250 per day per violation. And further, because this is not homestead, that any fines that are recorded by the city could become a lien on the property and on any other property that you may have. And non-homestead property is subject to foreclosure. So I just put that out there as a word of warning, word of caution. But I'm sure that you will diligently get this taken care of, and I do wish you well. So thank you. All right. So the next hearing that I have is a Massey hearing. Case number 2022-090, and there were a number of violations set forth in an order that I issued on March the 6th, 2023, stemming from a hearing on February 28, 2023. And Mr. Robinson, you may proceed.
Yes, sir, this is case number 22-090, 7000 North Atlantic Avenue. This is the Massey hearing for the property conditions. The magistrate orders were sent out on 3/15/23, return receipt 3/20/23 to Clayton Castetter.
Okay, wait, let me just get that down here. So the order was sent, certified mail, return receipt on 3/20, and then the notice, that was the order. Then the notice of hearing on 4/5/23, and then a return receipt on 4/10/23. Okay, I got it.
This is the subject property.
I remember.
I'm not going to go into all the details again, but I went out today, and a site visit revealed the property has been mowed and the trash and debris cleaned up. The golf cart has been removed. An application has been submitted for a permit for the accessory structure on April 24th, yesterday. The dumpster still needs an enclosure, and the roof repair still needs a final inspection, which we gave them until the end of the permitting, which is
Sometime in June, right?
Yeah.
Yeah.
Yes, sir.
Okay, so There's an application for the accessory structure, and that is that like tent type
Yes, sir.
thing?
Yes, sir.
And that was submitted yesterday,
Yes, sir.
but no application for an enclosure for the dumpster, correct?
No, sir.
Golf cart removed. We still have the dumpster issue. Looks like the grass and weeds are taken care of. The trash and debris is taken care of. The golf cart's taken care of. There was also outdoor storage of mechanical equipment of some sort.
Yes, sir. It's all cleaned up.
Cleaned up, okay. And then the that canopy structure, I guess the issue that I had was the distance from the building. There was a is the location, assuming that's permitted, is that okay?
The location's at now. I've got the photographs. That location right there, which is the same as it is right here, that's fine.
Okay,
That's acceptable for that location there.
okay. So so we need that permitting completed.
Yes, sir.
For one thing, and then the other thing is just taking care of the dumpster. That's getting it properly enclosed. That's what we have left.
Yes, sir.
So we have significant progress.
Yes, we do.
Okay. All right, and then I have the permit expiring on the roof on June 2nd, 2023. So that's not ripe to be determined tonight.
That's correct. They have. I think it doesn't expire till the 26th of June. So they have a little bit more than 2 months.
Okay.
2 months and 1 day.
Okay, that corrects my information. So June 26, 23, permit expiration. Okay. All right. Anything else before
No, sir.
the respondent has an opportunity? All right, thank you. Is anyone here to speak for the respondent? If you could please introduce yourself, your name and address.
Good evening, I'm Kevin Markey, I'm legal counsel for the respondent Clayton Castetter II.
And Mr. Markey, is that Markey?
Yes,
Okay, thank you.
that's more difficult than you would think sometimes.
Okay, sometimes I get it right.
My office address is 380 South Courtney Parkway in Merritt Island. And of course, I'm a member of the Florida Bar. I point out that I'm representative of the respondent Clayton Castetter II in large part because in attendance with me tonight is Clayton Castetter I, his father.
Okay.
Mr. Castetter II is in graduate school, unable to attend. So
Okay.
should the formality arise, looks like it's not going to, but I do want to offer into the record a durable power of attorney that I prepared on behalf of Mr. Castetter II that would enable his father to act on his behalf tonight. His father is also a material witness, and he handles all the property management, so forth.
Okay.
So it would make more sense for the father to be here tonight anyway.
Okay. Sure, we'll call this Respondents Exhibit 1, and they'll be entered into the record. All right.
As a predicate, I wanted to mention a couple of things that I not only feel, but I'm confident are important, is the post office box utilized by both Castetters is in the name of Clayton Castetter I, and both of the certified letters sent in November of last year and February of this year, as best I can tell, we've determined were not signed for by Mr. Castetter, either one of them. I inquired with the post office what the protocol was there. They said it's customary for them to put a notice in the box and have the box owner or whomever has access to the box sign that notice. It did not happen in either case. And so the best guess by the post office is what was that perhaps an employee there just signed it and processed it. That's material for a couple of reasons. Primarily, they don't check the box every day, and so that sat in the box without them knowing for a week, 2 weeks. And the point being, point number two, is at no point would I want the city, whether it's code enforcement or Magistrate Geller, to assume that these folks are not diligently trying to take care of things. They're behind the 8 ball in terms of notice. So I just wanted to inform everyone of that. The second part is that I'm aware also that the notice one or more times was posted on the building. Building has how many tenants? 6 tenants. He never got wind of those notices. No one's there every day other than tenants, and so they were removed. And third, the compliance issues, most of them, golf carts, RVs, etc., although now in compliance, we had to deal through tenants to get that resolved, and that doesn't ever happen yesterday. So again, they want to demonstrate that they've been pretty diligent in compliance, and I'm pleased to hear that the inspection today indicates that they largely are in compliance.
Let me just, you raise an interesting issue here about the notices going to the post office box. Does it make sense to have mail going to where you're going to receive it, and maybe this post office box isn't the best option for the Castetters?
That's a thought.
I'm just throwing it out there. I previously found that there was compliance with the city code and the Florida statutes in giving notice because of the posting, both at the property and at City Hall. That's sufficient under the law. But I'm sympathetic to the idea that you may not be receiving something, you may get behind the 8 ball not knowing that it's there. And I'm just thinking aloud, going forward, just, the Castetters may want to see about what they can do to make sure that they receive anything from the city or anyone else, in a timely manner.
For example, I don't know, notifying the city that maybe there's a box they could affix to the building, and if they're going to put notices that they can go into that secured box, and that way we know to check it and we know it's there. Thinking out loud, I understand your point.
Well, I think the addresses typically come from the property appraiser's office. Is that?
That's correct.
Yeah. So maybe whatever address is on file there.
Well, that's generated. I do a lot of dirt law. That's generated by the address that's listed on the deed, and the address was a post office box, because that's where they do all their business, and so that's what the property appraiser uses. And again, I'm not arguing with the fact that in black and white terms that the city tried to comply with the statute.
Well, let's go ahead and proceed. We were kind of belaboring this point, and but I'm not going to hold against them the fact that this was sitting in the mailbox for 2 weeks.
That's why I shared it with you.
Okay. All right.
If I can remember correctly, I think we're looking for just a couple of things. A final inspection on roof repairs that were predicated by a storm event. So they were more or less emergency repairs, relatively minor. It was 1 or 2 squares. That terminology is what, a 6 by 6? 6 by 10 by 10, thereabouts. So not huge, but nevertheless precipitated leaks and angry tenants, and so we tried to get to it as soon as we could. That roofing part is done. I think the finish work is not done because we can't get the roofer back out there because this is 2023 and good luck getting people to respond in a week or so. So we didn't want to call in a final for the roof part until we address the fascia part that is yet to remains to be done. Again, we're working on that. Had zero problem calling in the final inspection once we can get that rectified. The second one would be the dumpster enclosure. I'm going to show my age a little bit. There used to be a day when you could go to the building department and provide a sketch of the work that you were going to do, provided it was not constructing a building. But if we're simply putting a fence that can be moved if it's 5 inches in the wrong place, you used to be able to do that. They're, according to my client, the building department is insisting upon, for both the enclosure of that temporary structure and the enclosure of the dumpster, insisting upon an as-built survey. An as-built meaning demonstrates the location of all structures on the property. That, my client has consulted a surveyor for whom I've known 30 years, who's 6 weeks behind, as are most surveyors right now. So, 2 things. He's working on compliance on the last few remaining items. The ability to get a survey obviously is out of our control. As I said, I do a lot of real estate work, so I've given my client some alternative surveyors to perhaps use who aren't so backed up. Mr. Campbell, whom he did consult, has been in the county for, I don't know, 40 years. So what I would like to see is a recognition that we're in compliance with the other matters, that we are pursuing closure of the outstanding matters. And if we could have, I mean, I'm told by the client that the surveyor just told him a few days ago, give me 4 to 6 weeks. So if we could get 60 days, 90 days to work on those 2 matters, none of which are critical to safety, welfare. I'm curious, not to poke anyone in the eye, but I'm curious why the animal hospital, for example, right next to us has a dumpster with no fence around it. Maybe there's exceptions depending upon the type of business and location, but our dumpster is behind the building, not readily observable from A1A. That dumpster is readily observable from A1A.
I'm sure the code officers are taking note, and
Well,
of this publicly stated violation, and they'll check it
perhaps,
out.
maybe
But I don't think the city is going to be making exceptions for anyone. I mean, the code is to be applied uniformly to everyone.
I will ask, because I'm curious, because that's my training. The code, as I read it, says all commercial establishments shall be required to have mechanical containers, which is a dumpster, and quote, at the discretion of the city manager. So, I guess the question is, how is my client supposed to know that the city manager has made that decision? What's that process? Because he was using individual cans, or not he, the prior owner of that property, which is over 20 years old, has been individual cans
Right.
forever.
Right, and it was determined to be inadequate for when you have 5 or 6. I can't remember how many tenants were there. That was inadequate, and so you needed the larger dumpster there.
Understood.
And so that's
It was
we're kind of
determined to go wide now and not 15 years ago, but anyway.
yeah.
So,
Well,
that's what I'm asking. If we can have additional time, I'm confident that those outstanding issues will be resolved once we get a survey.
All right. I think 90 days is way too long. 60 days is quite long in my view, and I haven't even heard what the city thinks. But anything else you want to add, Mr. Markey, before you sit down?
Yes, again, I've worked in this community my entire life, and I do a lot of real estate law. For a surveyor to tell you it's going to be a month or longer is not out of the ordinary. In fact, it is the standard.
Yeah, I would say this is a very small job, and just where.
Which is why a surveyor doesn't want to do it.
Yeah.
They're making more money doing developments.
Yeah.
In Titusville, et
Yeah,
cetera.
I get that. I get it. Yeah. Okay. Anything else?
Did I miss anything? All
Okay.
right.
Well, thank you.
you.
Thank you, sir. Thank you, Mr. Markey. All right, Mr. Robinson, what response do you have to all that?
I can't speak intelligently about how long it's gonna take for a surveyor to come out here. We have no problem continuing to work with them.
Okay,
You know, 45, 60 days. We've been working on this case for several years now. I don't see why another 2 months is gonna make a difference.
so question is, do I hold fines in abeyance while we continue this matter for another couple months to give them a chance to get it done? Is that what the city is leaning towards?
I would recommend that we could come back. If nothing is done, I'll have a Massey hearing.
Right.
And then we can make these fines backdated to today's date.
Okay.
If it hasn't been taken care of.
Okay, so what I'm gonna do then is I'm gonna issue an order tabling this matter for 60 days or until the June meeting, whenever that is. That's the fourth Tuesday in June. Do we know when that will be? June 27, 2023. And so the Massey hearing will be tabled until June 27, 2023. At that point, if this is not totally taken care of, I'm not going to have a whole lot of sympathy. So we're talking more than 2 months to get this taken care of. And again, we're just dealing right now with the dumpster enclosure issue. That's the main sticking point, and then we won't even be dealing with the roof until that permit has expired if the roofing work is not done. So right now, there's nothing to be done on the roof matter from my standpoint today.
That is correct.
Okay, so that's how we'll handle it then. And then if for any reason I need to issue fines at that June 27th hearing, those fines will be backdated, not only to today, it would probably be backdated to the date that was set originally for compliance, which I could probably find it in my materials. I think the violations were ordered for compliance to March 17, 2023. So that's what they would be backdated to. But you have fine counsel, and we'll give you till that hearing in June to get this taken care of. So, thanks very much. Thank you. Anything further from the city?
No, sir.
All right, then we'll adjourn tonight. Thank you, everyone.